Hi, everybody. Good morning. I'm still letting people in. We're still logging on. So bear with me. Do I have you guys with me yet? I do. Okay, I see that. Awesome. So if anybody has a question for me while we're waiting for people to log on, that's fine. If you want to wait, that's fine too.
Yes, Patty, hi, this is David. I have a question here. Okay, the form that we're supposed to send before February 28th,
Yes.
this exact form is printed by California Apartment Association, but the only difference is that on top of it, it mentions the name of the tenants and the street address and all that. Is that necessary to have this name on top of each of these form when we're sending it, or no, or the section, the housing is key without any name of the tenant on top?
I think it would be a better business practice for you to go ahead and allow to have their names and addresses on the front of those documents. It gives it more of a personal and business professional touch than just not having anything on it at all.
Yeah, also, reading all the fine prints, it says that if there is a unit or an apartment that has more than one person on the lease, each one of those tenants must be sent a form, even though they're being sent to the same address.
I'd have to read the statute. I have it here. So I don't know if you want to wait for me to read the statute. I haven't heard any of that. I don't know why they would make that part of California civil process, because you could just as easily put all the tenants' names on one document.
Okay, one last question. From some law offices, they're telling me that they prefer sending these certified mail to all tenants. And my question is, if you do that, some of the certified mail may not be accepted by the resident of the apartment. And
absolutely.
So
do you sign? I got a question for you, David. Do you sign for a certified letter when you don't know what's inside it?
Okay, so if they don't sign it, that means that they weren't served, they won't be valid, right?
Correct. So why not just post and mail a copy or personally serve?
Okay,
that's the easiest.
Okay, so my plan is just according to an option. I don't know if you agree to it. You can mail it, but you don't have to post it. But you do fill out the proof of service as you mass mail everything. You follow me?
I follow exactly what you're saying, and I would just be concerned that that would be proper service in the eyes of the court.
Dylan, Christy, Greg.
You guys hang on just one moment for me.
Kelly.
Okay.
Daryl.
Okay, sorry about that, you guys. They're using the intercom system here. I'm like, oh man, you guys don't need to hear all of that.
So you're saying that even though I have the option of mass mailing and filling out a proof of service, you say in the eyes of court, it is necessary, mandatory to post and mail instead of just mailing and do a proof of service.
Correct. In the eyes of the court, when proper service would be, and this is me just talking to you about process and procedure of the court, when you serve a document, the proper process and procedure would be, as far as proof of service, would be personal service, sub-service, or post and mail. So if your legal counsel is recommending you do that a different way, then by all means, listen to your legal counsel. I'm not an attorney, remember? So my brain is geared of following the process and procedure of the court. So it's going to be post and mail, personal service, or sub-service. And I don't like sub-service. It can be a little risky at times. So it's not a way that I prefer to serve a document.
But Patty, believe me, I just talked to someone in fast eviction. They said that it was send it all certified, which I don't agree for the reason that we already discussed. So I will be doing post to be on the safe side, post and proof of service, mail, mass mailing. So that's what I'm going to do then. Thank you.
Okay, perfect. Anybody else have a question for me? But or I'm going to get started here. We're going to talk about Senate Bill 91 and some of the key factors that we see going on with that. Hold on, I see a message at the bottom. I'm comparing SB 91 forms from AOA and CAA. The people using CAA include the actual blank declaration of the COVID-related financial distress. Yep, that's a requirement. What CAA is doing. You have to give them the copy of the California Act that helps protect them. You also must give them a blank declaration for them to sign and return to you. So 3 documents have to go out when you're doing that 15-day notice to pay, rent, or quit. And that's the declaration from the state explaining to them what their rights are regarding Senate Bill 91 about the 80-20 and the 25% and all those moving parts. And then you also need to give them a blank declaration that they would sign and then return to you, and then the actual 15-day notice. So here at Fast Evict, I know people are like, you're kind of expensive. And I'm like, yeah, but we're serving you a series of documents that put you in line to go after the money later. So just something to take into consideration. But if they're not delinquent, you don't necessarily have to serve that document. I'm sorry, you guys, I'm on a slick floor with wheels and I'm rolling everywhere. My feet don't touch the floor. Shh. So I move around a lot. I'm sorry. Let's see who else. We got more people coming in and joining us. Anybody have questions about the moving parts of the Senate bill? Please, I just want to put in everybody's head, they added 2 pages of retaliatory issues. So we need to make sure that we're not retaliating. That's expensive. They implemented fines that could be issued by the court for the retaliation, which is also scary. So be careful what you're doing. Make sure your legal counsel is aware of all the moving pieces and parts. Nobody wants to be fined, and none of us want to be susceptible to a lawsuit unnecessarily. I mean, tenants are going to do what tenants do. And I shouldn't say that. I should say humans are going to do what humans are going to do. You're either a good human or you're a bad human. There's no in between. So just want to make sure that you understand now there's fines that come with this, okay, if we're doing this wrong. So since the pandemic started, I've been trying to warn everybody, we've got to be careful that we're not doing something that's going to come bite us later. And we're now starting to see that. You guys, if you've done a rent increase at all during the pandemic and your tenant has been delinquent at all during the pandemic, you must reverse those charges. That increase is considered retaliatory. Do not pass go, do not collect it. Fix your ledger and fix it now. Give them a rent credit if they paid, tell them that it was an oversight and their increase has been rescinded, and get your ledger square. Remember, you can't have any late fees on your ledger for the COVID period, and we're just gonna boom, COVID period, okay? March of 2020, all the way through June of 2021. That's the COVID period. It kind of puts a bubble around the tenant. We can't ask other landlords if they've been late during that time period or if they were delinquent during that time period. They're protected. And I saw something really cute, and I'm probably going to write an article. If they've been affected, they're protected. And it's just an easy way to try to remember what we're doing. Somebody asked me if we can't inquire about if they were late during the COVID period. Here's the reality. I don't care what somebody else discloses to you. I care what's coming out of your mouth. So it's you that needs to be careful that you're not giving out that information. That's where the penalties and fines come in. So zip it, you guys. Giving out information is extremely difficult and challenging at times. I know in corporate America, we use this little tool saying, I'm sorry, we're not allowed to give personal opinions. Yes, they did live here. They lived here for this amount of time. And that's probably about all I'm going to answer. So just another way to handle that. And I will tell you guys this. If you ask a professional manager how their tenant was and you're not getting a whole lot of answers, ask them if they'd rent to them again. Everybody write that down. Would you rent to them again? And if they say only if they qualified, something is going on there and they can't tell you, but chances are it's not a good relationship, okay? It's like a code with all of us professional property managers of us saying, if they qualified, we can't tell you they've been in eviction. We can't tell you they're being evicted. We can't. So just a key there, most property management companies, as soon as you say, would you rent to them again? If they say only if they qualified, chances are there might be a problem there. I saw something else come through. Let me see what that is. I spoke to an attorney who was wishy-washy on this. Since the only verbiage says to serve only late tenants, the attorney said it was my decision. The words on the form says it's only required to send to late tenants. Crap. I understand a lot of people were scared to send it to everybody on their list. In the beginning, everybody said, oh, send it to everybody. And here's my theory. A lot of us as landlords were like, I don't want to give this notice to my good paying tenant. I'm going to tell you something right now. If you're a good paying tenant intended on taking advantage of the COVID pandemic, if you will, how do I say this without, I'm choosing my words carefully, so give me a second. Your honest tenant is going to continue to be honest. And then the tenant that is trying to exercise their rights and make sure that they're getting taken care of and everything is in their favor, they're going to continue to do what they want to do. But serving a tenant that is paying and in good standing and giving them that disclosure, please know that isn't going to make them go, oh, look, this is how I be bad, because that person would be doing it already. We're at the tail end of this at this point. I do see light at the end of the tunnel. I can say that because now I'm seeing retaliatory issues in the Senate bills where we had not seen any of that before. None. Okay, so now we're seeing retaliation issues. There's actually 2 pages in Senate Bill 91 in regards to retaliatory issues. So number one, we don't want to get sued for retaliation. We sure don't want to get fined by the court for retaliation. So we need to be careful and cautious of what we're doing. But it also gave us time periods of that 6 months after, 6 months after. So starting to see those come into place tells me that the chances of this being extended again are actually pretty low. There's light at the end of the tunnel, you guys. They gave us rules. They gave us rules past the pandemic. So to me, in my professional opinion, I see that this may be coming to a close most likely by the end of June, and we can move forward. When you're doing a disposition of security deposit right now, one of the things you need to make sure you are aware of is if you're charging for rent in that disposition of security deposit during the COVID pandemic, you have to get written permission from your tenant to deduct COVID rents from their deposit. Everybody got that? So if your tenant moves out yesterday and you're doing the disposition and they owe 2 months of rent during COVID, you can't put that rent on that disposition of security deposit. Okay, you have to actually give their deposit back and then sue them in small claims court in August for the rent that was owed. Everybody following me? So be careful that you don't put COVID rent on there unless the tenant signs and agrees stating that you can use their deposit for the past due rents during the COVID pandemic. Remember, big bubble, COVID, they're protected. Okay, so starting to see a couple of those come through and just trying to tell people, hey, don't do this. You can't do this. So definitely something to be made aware of. And remember that doing a dispo, don't put the COVID rent in there, okay, unless the tenant signs and agrees. It's consumer debt on the balance that's owed. It's convoluted and construed all over the place, and you just don't want to set yourself up for failure. So in the event you have a tenant vacating and they owe rent during the COVID period, and your charges for cleaning and repairs don't cover the deposit amount, you're gonna have to go talk to the tenant and ask them if they want you to take the unpaid rents from the deposit. I get it, I know, but you have to. You have to. Just saying. So that's where I wanted to focus today, is not only on the here and now and going after the money, and we'll talk about the money in a minute. But just want to make sure everybody understands, if you have somebody vacating now, you cannot charge rent and deduct it from the security deposit. Very, very important that we're not making that mistake. It could be very costly. Hang on, I see a question. Even if they paid all the rent during the COVID period, but now they want to move, if they don't pay the prorated rent to move out, date early in March, you can't collect rent from the deposit that was due during COVID period unless the tenant signs and agrees. The only place you can go after rents that were due during the COVID pandemic is in small claims court, and not until August 1st. Okay? Don't put it on your dispo unless the tenant signs and agrees to it. It will bite you. We don't want that. So I know I've talked to everybody about going after the money. We can apply for that first of all on March 1st. I'm sorry, I misspoke. March 15th, you guys set your alarms for 4:45 in the morning, because if that website is running off of New York time, they're 3 hours ahead of us. And when the money's gone, the money's gone. I mean, this is our bailout, so to speak. This is not a loan. I don't know how difficult it's going to be to apply. I would assume that because we're dealing with the government, that you're going to need your tax bill handy. So they're going to probably reference the legal description of your property, which is not the address. It's in fact the APN number. Do I know that this is what they're going to ask for? Absolutely not. However, I do know that it makes sense to me, if that makes sense. I mean, the government's the one giving us the money. The government's who we pay our taxes to, but they don't recognize the address. They recognize the APN number. So just something to think about when you're gathering up your ducks to go apply for the funds that are owed to you. And make sure your ledger's square. Remember, during the COVID pandemic, they want the ledger broken down by month to month and not most outstanding balance applied first. So that just applies during the COVID pandemic. Make sure you guys don't have any late fees on there and you don't have any other charges to the tenant. What is your opinion about mass mailing with proof of mailing this form before February 8th instead of getting it certified without posting? You can go ahead and try that. Here's what you're asking me. How well can your attorney argue that in court? That's what you're asking me. Just so you completely or kind of understand what it is I know the proper process and procedure for serving a document is based on what you can fill out on a proof of service, which is post and mail, personal service, or subservice. And I always pause when I say subservice because I have to, number one, remember what it's called. And number two, I don't like that one. Usually when you subserve somebody, you'll get to court and find out that they're a very large adult and that they weren't an adult, they were a minor. So a lot of times we see that as a defense, and unfortunately it flies. So I try to avoid subservice at all costs just because I don't want to expose myself to that. It happens. I mean, it is what it is. So for me, it's if a little kid opens the door when I go knocking and talking with my notice in my hand, I'll ask them, do you have an adult home? And sometimes I'll just say, oh, I'm sorry, I didn't know that you were here. This is for your parent. So I'm just going to go ahead and post this on the door, and I have to do it that way. So go ahead and shut the door. I'll tape the notice on. You have a nice day. So I don't, if they take it off, they take it off, but I post it on the door, make sure I take a picture that I posted it on the door, even if there's a minor at the property wanting to talk to me about it. I don't talk to them. It's too risky. It can really affect your interactive process, which is the legal term for the conversation that you have with the tenant. So you want to be careful you're not violating that. Get back into talking about the money. You guys apply early. When the money's gone, it's gone. I don't know what your tenants are going to have to fill out and or sign and agree to. I don't know what's going to happen with the program. I have a feeling it's going to take some time to disperse the funds. That money is not going to be available to you on March 15th. So please don't go into it with that mentality. I think it'll take a couple of months to get payment. And the way I look at that is pretend you're applying for unemployment. I mean, it's not something that happens rather quickly. I'm assuming it's the same process when you apply for assistance from welfare or food stamps or medical insurance through the government. It's a process. It takes time and they need all their ducks in a row. Also, please pay attention to the fine print. And I can't end this enough. I have a feeling somewhere in this, they're going to say, we're going to pay you 80%, but you can't terminate your tenancy with your tenant for 6 months or 24 months or however long it be. The whole reason that they designed and developed this bailout money is so that half the state of California would not be homeless. And people kind of giggle when I say that, but you guys got to remember, us as independent landlords are trying to protect ourselves right now. And one of the tools that we have for us is our criteria. So I'm seeing a lot of independent landlords raising their criteria to a spot that they don't even qualify to live there. And they're scared. And I can't say that I blame them. We don't want to rent to somebody that's going to move in today and stop paying us tomorrow. Okay, and say I've been affected by COVID. I mean, it is what it is. It's only a matter of time before they pass laws and regulate it, so we can't do that. Okay, it's like every time we come up with a process and a procedure or a system to deal with something or to handle a situation, that's when we get new laws that put stop to that. So I have no doubt that within the next year or so, we'll see regulations on our criteria. You watch, because that's what the problem is right now. There is housing, and I'm talking about independent housing, not multifamily commercial property or commercially ran property, if you will. In other words, corporate America. They don't seem to have the problems that us as independent landlords have. And I have no doubt it's because of their professional management skills, just saying. So it's two different beasts there, but for the most part, single family residences are being extremely diligent on who they're letting move into their properties. And it's making it difficult for other tenants to get out of your house if they can't qualify to live somewhere else. So one of the reasons the government did this is so that half the state wouldn't be homeless. Now, I hope what I just said and all the verbiage behind it puts that all in perspective and makes sense. But that would be the why there, just so you understand why they're giving us money and not the restaurants or the nail salons or the hair salons, is because they don't want half the state homeless. And let's face it, if we were going after non-payment of rent, that's exactly what would most likely happen. For those of you that are looking for eviction to help you, please let me throw this in the caveat. And don't get upset with me. Don't shoot the messenger. And I could tell you county by county, but this is the reality. If you're looking to evict your tenant and that is the mindset you have, and that's the road you're going to go down, please know that it is currently taking anywhere from 3 to 6 months for an uncontested case. 3 to 6 months, uncontested. That's a long time with no income. And you're spending money for legal. So just something to take into consideration when looking at the big picture regarding this whole pandemic problem. I mean, I never thought in a million years the government would tell me when my rent was due and rewrite the terms of my written contract, but That's what just happened. That's where we all are, and it's not fun. Anybody have things specific that they want to talk about? Any questions somebody has? I want to get you guys your questions answered. Hang on, April has a question. I have a friend that's renting a room and they lost their job. She has not paid rent for a couple of months. Can tenants that are renting only a room apply? I believe this applies to all residential dwellings. That would be rooms. That would be any tenant, an oral agreement. Exactly. It's worth a shot. I mean, what's the worst thing that's going to happen? The program's going to tell you no. Go apply. See if that helps. There's a lot of tenants out there on oral contracts, believe it or not. And yeah, I would encourage them to apply too. I mean, here's the resistance I get, okay? And just bear with me. Some landlords say, I don't want to give away 20% of my income for 80% for the government to pay. That's not fair. That's not fair to me. I have this to ask you. What's the government doing to help the restaurants in your neighborhood, the nail salons in your neighborhood, or the small businesses that have been shut down during COVID with no income in your neighborhood? I can't hear you. In other words, they're not doing anything. I know it's a big chunk to swallow 20% of the money that's due to us, but the reality is the alternative sucks. Let's talk about the alternative. 25% of the rent is due on or before June 30th. And the other 75% becomes consumer debt, and you can sue in small claims, but not until August. And they are making small claims court unlimited in August just for this. But here's the one that makes me go, what? That consumer debt is unassignable. What does that mean? That means that you, as the landlord, have to collect on that 75%. We're talking writs of execution filed with the sheriff's department to garnish wages. You have to do it. You can't give it to a collection agency. You can't hire an attorney to do it for you. It's unassignable. So that debt, you can't assign to someone else to do the collection. You have to do it. How difficult is that? What do you guys know about writs of execution and how to obtain them? It's almost like they're forcing us to go after that 80% to depend on them, you know? And then they're gonna say, well, we helped you, you watch. But there's something there. It's just, they're making it totally impossible for us to go after that money on the 25-75 split. Because yes, we could go get a money judgment against them, but what are you gonna do with the money judgment? Do you know how to garnish wages? I don't. Over my pay grade, I don't do collections. I know this much about the collection process. I got nothing. Still letting people in, so bear with me, you guys. Like, hello, come join us. So we talked about the money. We talked about how to get the money, apply early, get up at 4:45, you guys, because when it's gone, it's gone. I have a feeling we're going to have to jump through some hoops to get the money, and the money's not going to come quick. If I had to guess, I'd guess we'd receive the money sometime in June. Kind of makes sense, right? All right, anybody have any questions for me? Any concerns? I know we've talked a lot about SB 91, but there's a lot of moving parts to it. I mean, it's insane. Make sure you're disclosing to your tenants that are delinquent by the end of this month about this program. But I have all kinds of questions. I had a conversation with an attorney this morning before I started this, and now I have all kinds of questions, but I don't want to scare anybody, so I'm being very quiet. but there's a lot of moving parts throughout this entire pandemic, and they threw a lot of laws at us in a very quick fashion. You know, they passed the law of AB 3088 on September 1st and said that you need to notify your tenant about their rights by the 30th, or else what? Well, did you read the fine print? Or else you forgive the rent owed from March through August. So my question becomes, please tell me you guys did that. I have no doubt we're going to see BOSTA and the Eviction Defense Network starting to bring that forward in the trials that are going on, that if you didn't notify them of their rights, that rent isn't owed, and why are we in court today? So we're starting to see a lot more contesting tenants right now, just so everybody knows. They're filing answers like crazy. They're filing motions like crazies, demurs, ex parte hearings. They're really reaching for straws to stay in the property as long as possible. So where you think a normal uncontested eviction, 3 to 6 months, is a long period of time, if you get a tenant in there that files an answer, buckle up, because it's going to be even longer. And they're being extremely litigious. I don't know a nice way to say this, so I'm just going to say it. You guys can all yell at me later if you want to, okay? Here's how I want you to think about it. A lot of law firms and attorneys have been shut down for 6 months in the beginning of this pandemic and didn't have any source of income, not only on our side, but also on their side, okay? So the tenant attorneys are trying to make up for it by filing all these frivolous motions, because that's how they get paid, by defending them. Because then we have to go to court and defend and have our attorney defend us against their frivolous motion, even though it's frivolous. Yeah, getting involved in a case right now that's litigated can be lengthy and costly. And we are seeing some of the judges now where in the beginning of this, they would say, oh, you didn't fill out the declaration. Well, here's a blank one, go ahead and do it. We're dismissing the case. The courts aren't doing that now. We're not seeing that now. They're not handing them the blank declaration and dismissing your case. They're basically saying the time's passed. So the courts are now starting to, if you will, get on the bandwagon of the landlord and not being so ready just to hand them that and say, okay, fine, here, sign it, case dismissed, everybody go home. So we're seeing that change happening too, where the courts are being more susceptible and more supportive of landlords. For those of you that still have to call law enforcement and try to get assistance from them, I'm sorry. Don't get frustrated with them. They get their orders from a higher power and their hands are tied. It makes it extremely difficult for them to make arrests right now or to eject someone from the property. I didn't say evict, I said eject, because of the COVID pandemic. Their hands have been tied tremendously. I mean, they were on a no arrest hold for a while, so they couldn't even arrest people and take them to jail because they were afraid they were going to bring COVID into the facilities. So we're starting to see that change a little bit, but not much. Law enforcement's hands really are tied, and that doesn't help us in our day-to-day operation, especially if we have a nuisance going on at a property where we need those police reports in order to evict. They work for the government. They know what we need. They know what's bad and what's not bad. What's bad to us may not be bad to them. So I get it. It's extremely stressful times and can be extremely stressful. Extremely stressful. Hold on, Val, I see you have a question. Let me see what it is. Hang on. Does this apply if you're evicting to move into the home and not evicting for payment of rent? Do I apply for any of this stuff? I would talk to your legal counsel and ask your legal counsel if you could apply for the funds even though you're in eviction. I'm not going to answer that question. I'm not an attorney. I got to protect myself, you guys. I get what you're asking me. I know what you're asking me, but I'm going to protect myself and say, if you're asking for direction, you should contact your legal counsel. That way I don't say the wrong thing and put myself in a sling, okay? Do you suggest we do not send, hold on, let me read this again. Do you suggest we not send a cover letter, or would it be smart to send a text alert alerting tenants that this notice is arriving and it really does not apply to them? I don't know what you mean by that, because I know I'm your legal counsel, but I'm not an attorney. Fast Eviction Service is your legal counsel. Remember, I'm a real estate broker. I don't practice law. I practice property management, okay? It's just me protecting myself. Could we think outside the box on these? Yes, absolutely. Will we all? Yeah, it's scary, you know? Let me read that question again. Text messaging doesn't count in the eyes of the court, but they can and will be used against you, but you can't use them as submissible evidence in court. Sending someone a text message or an email does not constitute proper service, so that wouldn't apply. And the reality is you're sending this to your delinquent tenants. You don't have to send it necessarily to your tenants that aren't delinquent. And I wouldn't be worried if it accidentally went to a tenant that's not delinquent, because reality is if they were planning on manipulating the system in their favor, they'd be doing it already, okay? What you tell them isn't gonna change that. Your good tenants are still your good tenants. And I don't mean good, I should say good paying, okay? So your tenants that are paying right now, they're not gonna find out about this law and stop. For the most part, they're trying to be responsible humans by continuing to pay you as agreed. Fair enough. Okay, let's get into questions. Who has questions for me? And I'll do my best to answer them. Nobody?
Patty, I was in an eviction yesterday, and it's amazing how judges, even with cause eviction, are taking the side of the tenants. It was really amazing. Things have changed a lot. That's just a comment I just wanted to make.
Things have changed a lot since when, David? Since a pandemic started, or in the
Yes.
last 6 months? You tell me.
Well, I wasn't there since this case goes back to 3 months ago, and finally we got eviction done through settlement with the tenant, because the judges, according to my attorney, are very, very pro-tenant, and he was basically really apprehensive about taking it in front of a judge. He did his best, and he succeeded in making a settlement with the tenant. That's exactly his wording. That is very hard, even with cause, to get a favorable outcome for the landlord.
And then David, if you don't mind sharing with us, please, can you tell us just what county this is in?
No, this was right here in Fontana, San Bernardino.
Okay. And I'm familiar with what you're speaking of. I know exactly what you're talking about. To get judges on our side throughout this pandemic has been extremely challenging. And I'll give you guys an example. Remember when the courts were closed and we could only file an emergency ex parte hearing to get permission from the judge to even file an eviction? And it had to be really bad for us to do that. I'll tell you right now, I'll give you 2 examples because they happened through the firm here. So I have some knowledge of them. There was a shooting inside a unit where one resident inside an apartment community shot another resident inside the unit. Okay, so we wanted to do an emergency 3-day quit, start eviction. The residents happened to be affiliated with gangs, and the rest of the residents in the community were in fear for their own safety. So we filed an emergency hearing order and asked a judge to give us permission to go ahead and proceed with an eviction based on, I don't want to say based on a shooting, because I can't call it, it's a crime and it's still being investigated. So I have to be careful what I say. Based on the shooting in the unit. And the judge said very calmly, but the person that pulled the trigger went to jail. So the threat's gone. Your motion's denied. That judge left all those gang members inside that unit and made it so all those other surrounding tenants were trying to move seriously. So judges have become extremely protective, not over tenants per se, but over COVID. They're trying to avoid people from being homeless and the streets filling up, because come on, remember us little landlords? We're not going to rent to them right now. We're scared. We want to get our rent money. We don't want them to move in and cry COVID and then not pay us. And that ties our hands again. So it has been extremely difficult to get rulings and get judges on our side. We had another property where building and safety had red tagged the property saying it was uninhabitable and we couldn't get the tenant out. They wouldn't leave. So we asked the courts to do an emergency ex parte hearing so that we could do an eviction based on the fact that it's uninhabitable. And the judge said, I don't recognize building and safety as having any authority in this matter. Motion denied. Building and safety is their own people. That's police power. No words. I got no words because I'm dumbfounded by how the courts are acting, but I also get it. Remember this, they have executive orders. They have orders from powers higher than them up the totem pole on a federal level. So this is what I try to explain to people. If you're going to court to ask a judge to do an eviction, especially on cause, it better be so bad of what's happening in that unit because you're asking a judge to defy a government order because what's happening in your property is so bad, you want to kick them out. So that's one way to look at it. It's got to be bad. You need arrest records, a murder, death, suicide, code enforcement, building and safety. I mean, you need teeth in order to be successful in an eviction trial unless you can come to a settlement agreement. Settlement agreements are extremely popular. They really are. And I have no doubt we're going to see a lot more offers for cash for keys. We'll see how it goes. But even cash for keys, tenants can't find anywhere to go. They don't qualify to move somewhere else because people have raised their criteria to a level that they don't qualify. And let's face it, this has destroyed some of us as landlords, okay? And this is me talking to you, especially us independent landlords. Sometimes we'd say to a tenant, you don't have all the deposit, it's okay, I'll work with you. I'll work with you. I know corporate America won't work with you, I'll work with you. They're ruining that. They're ruining that. We're less eager to say I'll work with you because we don't know how bad that's going to hurt us, you know? So it makes it even more challenging. Okay, I see more questions coming through. Let me see if I can get them. I'm only saying it because I caused huge panic when without a cover or a text. Just let them know. You can let them know, hey, I'm sending you a letter of what your rights are. No reason to panic. It's just the new law telling you what everything is. So I get you, Val. You can send them a text messaging, letting them know that you're sending them a notification that's required by law about the program. So you have said to send to everyone later, not late. Yes. You must send it to delinquent tenants. I'll tell you that right now. You have to. And if that tenant becomes delinquent between now and then, in my opinion, it would be better to at least notify them and give it to that person, because you're not going to be able, let me put this in perspective for you, okay? If you didn't notify the tenant of these rights by February 28th, and you want to evict going forward for non-payment of rent at any time between now and June 30th, you can't if you didn't disclose to them about this tenant COVID protection by February 28th. Okay, so if your tenant is current now and becomes delinquent next month, you can't evict them for non-payment of rent during the pandemic if you didn't disclose to them what their rights are. See where it becomes a kind of an issue? You're not going to be able to apply for the money for the 80% through the government if you didn't disclose to the tenant what their rights are. So there's a couple of caveats that kind of hold your hand if you don't notify everybody. Hence why I said just notify everybody, because your good paying tenants are going to continue to be good paying tenants. If they wanted to take advantage of the system, they would have done it already. That's what I mean by that. So if you don't notify someone that's not delinquent and they become delinquent anytime from March 1st to June 30th, that ties your hands. Okay, just so you understand why I said serve everybody. Let everybody know what their rights are. That way, if they come delinquent later, you can do something about it. Otherwise, you're just gonna have to buckle up and go along for the ride. I don't like the ride. I don't like the road we're on. It's not comfortable. It's a little rocky, a little bumpy, and there's some crazy turns that keep coming at us. As far as us opening the state back up and us getting rid of COVID, and I don't mean COVID, the illness, I mean COVID, the restrictions, okay? I got a feeling that we're gonna start seeing more and more of the state opening up. I got a feeling that come June 30th, there won't be much extension if they extend it at all. They've put a lot of protections in here for the tenants, and that's what I was waiting to see. I knew that once I saw a lot of protections or retaliations or things like that going on, that's when I would say there's light at the end of the tunnel. Let me see really quick. What about a new tenancy starting in March? Do you need to give them the information? I would. What if they never pay you a dime? If you didn't notify them by February 28th, then you're not going to be able to go forward with that. So I would. That's just me. I'd do it. I'd do it. I'd do it. I'd hand it to them on move-in day if they were moving in on the 1st, and let my attorney argue in court that the intent to serve them in a timely manner was there. However, I was unable to because they weren't my tenant yet. So on their move-in day, I gave them the documents. That's what and I'd let my attorney argue it. Remember, that's what you pay your attorney for. And as long as your intent is there, you're giving them good grounds to argue for you. All right, anybody have a question for me? Nothing so far. Okay, I'll wait. I'll keep you guys abreast as to what's going on. So the end of this month, I think I was going to do another class, but I was going to do a class, and I haven't decided yet, but I'll let you guys all know via email what we're going to do our end of the month class on, unless you guys have something particular that you want to address. I have a whole list that I wanted to do for this coming year. So we'll placate that as it evolves. But we will definitely do something the end of this month. And if somebody has something in particular that they want to know about, whether it be preparing yourself for court, dispositions of security deposit, I'm going to do a small claims court class, but I will probably do that closer to August 1st, because that's when we're going to be able to do small claims with the unlimited amounts. So I'll probably do something for that more in June or July. Right before we're able to do it, so it's fresh in our minds still of what we can and can't do. So I think that would be most helpful. But if you guys have hints, something that you want addressed, I'd be more than happy to do that for you. I just need to know where I need to focus so that I can help you guys to the best of my ability. Also, remember, you guys can call me, email me, text me. Email is a really good way to get a hold of me as well. And we'll go from there. If nobody has any more questions, speak now or forever hold your peace. Well, at least till next Wednesday. I'll go ahead and end it, and we'll regroup next week. I'm going to have a couple of conversations with an attorney later this week. So we'll see if my mindset and my thinking is spot on. I don't want to tell you guys I have an idea, but I do. Because I just want to talk to them and make sure that before I say, hey, this could be a new business practice, let's talk about it. What do you guys think? I want to make sure what the legalities of it would be before I do anything. I do not want to set anybody up for failure. I don't like to set myself up for failure, so I sure don't want to do that to you guys. I saw something else come through.
Hey, Patty.
Oh, you're welcome. You're welcome.
Hey,
Yes.
Patty, this is Karen.
Somebody said my name. Where'd you go?
Yeah, Karen.
Hi, Karen.
Mark. Yes.
Hey,
just-
Carol.
Hi. I have been thinking, the last video that we had, I asked you about, I had the tenant that paid half and half, and you said, just take it if they're willing to do half and half. Okay, so
Right?
next half is up tomorrow, so we'll see what happens. But my question to you is, I'm going to give them that notice, but I'm going to give them that notice as close to the 28th as possible. What's required to notify them of the program. I have a feeling that they're going to be a problem. Now, I did a 6-month, a short lease with them. If they become if they become a problem and they, become delinquent, are we still allowed to not extend that lease? Is that still grounds for getting them out of there, or you know what I'm saying?
Okay. I thought you said, I thought you were going to say, are we still allowed to shoot them?
No, well,
no, that's just
no,
a
no,
joke.
I don't want to go to jail.
One of my jokes, you guys, just shoot them.
Okay.
It's faster.
I hear you. I hear you.
So could they become delinquent? Yes, absolutely. Could you apply for the funds? Absolutely. If their lease term ends on or before June 30th, Senate Bill 91 tells us that we can't terminate tenancy because it's the end of the term.
We
have a
cannot-
lot of people that have been end of term since March of last year and they can't do anything.
Are you kidding me?
No, I'm not. That's why
Okay.
I'm here. So in term is not a reason that you can terminate tenancy currently because of the pandemic. Remember, we have an order from the government to shelter in place. They're up here, you guys. They're above us. Okay, we're the last man at the very bottom of the totem pole. So unless you were going to move into the property, had a family member that was going to move into the property, and please, you guys, don't hear this much of the information and go, that's all I have to do to get them out, because you can't put that house back on the market for 3 years after that. And how they catch you is in your advertising. So I don't want to set anybody up for failure, but no, we are at cause evictions only, just cause, meaning you have to have cause.
And
non-renewal of lease is not a cause.
And the end of the lease is not cause. Oh man.
Non-renewal of lease is not cause.
Oh Jesus.
You could give them a term with like or similar terms, and if they don't want to sign it, you can evict them then.
Okay. Okay. All right.
But you'd have to offer them another 6 months with like or similar terms, meaning you can't do a rent increase, you can't change much of anything. And if they don't accept that offer and don't want to sign for a new 6-month lease, then you have cause.
Okay, would it have to be like a 6-month lease? Could you do a month to month? Because I have some people on a month to month.
Like or similar terms. No, you're going to have to do another 6 months. So in other words, you have to offer them something like or similar to what they originally have in place. And if they say no, then you can do an eviction.
Okay. And it has to be in writing or whatever that they say no. Okay.
And then let me say this to you guys, and you guys hear what I'm saying, okay? In the event that you have a fire or flood or some kind of damage in a property and you have to relocate a tenant, okay? In other words, there's been a problem, we have to do repairs, we have to relocate you. If someone's in a term for a period of time, you as the landlord have agreed to provide them habitable premises for that period of time. If they're on a month-to-month tenancy, your risk becomes much smaller in the event of something going badly, because it's much easier to terminate a month-to-month agreement than it is to terminate a term. Okay, everybody I just want you to think about what I'm telling you. So in the event your house burned down, and I'm just talking out loud, and the tenant didn't have insurance and you have a term, you're gonna have to put them in a hotel and for quite some time at your expense. So just remember, a month to month, the landlord has more control and more options. On a term, the landlord has less control and less options, because we can't do anything while they're in a term. We can't touch them. We can't change the terms. We can't raise the rents. We can't. It protects them when there is a term. When there is a month to month, it gives the landlord many more options.
Even with the COVID stuff, because I like I said, I just have 2 tenants that are questionable for me, and
Not with the COVID stuff. With COVID, let's just face it, you guys, COVID is its own little bubble and it's protecting these tenants. If they're affected, they're protected. And who hasn't been affected by this?
Yeah. Well, so
We
far,
all have.
so far, thank God I haven't.
Yes, you have.
Thank God.
You've had to buy hand sanitizer. You've had to wear a mask in public. You've had to buy a mask. You've been
Yes.
affected. It's a
Yes.
very broad term that can
Okay.
be easily
Yes.
argued.
Yes.
Everyone's been affected in some way, shape, or form because of the pandemic.
Okay.
Everyone.
Yeah. Okay.
I mean, even even past President Trump had to close hotels in other countries that he had. He was affected financially, without a doubt. I mean, everybody has been affected in some way, shape, or form because of the pandemic.
Right.
Even some of us landlords say, oh, I haven't been affected. Yeah, but your tenant's not paying you, therefore you've been affected.
Yeah.
So it's all in
Yeah.
perception, but affected, very broad term, easily argued by opposing counsel. I mean, it's
Yeah.
who's affected worse, I think, is who was affected better or who was affected worse, but everybody's been affected at some point or another.
Okay,
We've had to
so-
buy masks. We've had to buy hand sanitizer. I mean, those are additional expenses we didn't normally have.
Okay, so Patty, so that I'm really understanding, all right, because I do have let's say my month to month, most of my units are month to month, but this one particular person, month to month, they're on a month to month right now. I know
Okay.
that I have a feeling that when I give them this notification of this law, that they're going to take advantage of that because they've been itching at it since December. But they're they've paid on time. They've come through. All right.
Well, if they're gonna
but they're-
take advantage of it, they're gonna do it in one of two ways. They're either only going to pay you 25% of the rent,
Mhm.
or you can then turn around and apply for the 80% from the federal government.
Okay, but I don't do.
80% is a good chunk of change. It's better
Yeah.
than what these restaurants are getting.
But even though they're on a month to month, there's nothing I can do about the month to month when
Not unless you want to move back into the property.
Okay, no, all right.
I mean, the county of LA has even more restrictions than the rest of the state of California.
Yeah.
They are completely restricted. So let me say this to you, and please don't panic on me, and please think about what other landlords are doing and why they passed this to begin with. But in LA County, they even now say that a 24-hour failure to allow entry on a 24-hour notice is no longer cause for eviction because of COVID.
Mhm.
So what does that tell me? If you own a house in LA County, the law says you can't even go into your own house. So wait a minute, let me get this straight. The government rewrote our lease terms as to when the rent is due. And they're telling us we can't enter to provide habitable premises? I am blown away by the government power during this pandemic. I have to say that. I never thought in a million years. I mean, we're Americans, right? We're the land of the free because of the brave, right? We have a written legal contract. This applies. No, the government rewrote it about when our rent's due. I didn't know they could do that. That floors me, I'm dumbfounded by it. What else can they control that we think they can't? You know? Kind of makes you wonder. That's all I'm saying. Okay, Val, hang on, let me see what I got going on. Remind us if we are thinking of selling a home that the tenants are renting, we don't want to be under the retaliatory practices or penalties, but we legitimately want to sell the property knowing it would be harder to sell them with them in it. In LA County, you can serve a notice to terminate tenancy. I know, but I got to talk about LA County too, Val. In LA County, you can serve a notice to terminate tenancy because you have an open escrow. Okay, and the buyer intends on occupying the premises. Yeah, but you can't force entry in LA County. So you can't do an eviction for that if they don't let you in because it's for sale. So that makes it challenging. Anywhere else, yeah, as soon as you have an open escrow, you can do a 30-day notice to terminate tenancy that the buyer intends on occupying the premises, but not until you have an open escrow. And let me say this, you can serve a 24-hour notice to enter. And if they do not allow entry, you may be able to do an eviction for cause because they failed to allow entry. The reason I say may is because they added retaliatory issues in the Senate bill. If you've previously asked for rent during the COVID pandemic, and now you're trying to evict because they won't allow entry, that could be considered retaliatory. If you've never asked for rent money, meaning you've never served a 15-day notice throughout the pandemic, and now they're not allowing you entry, you more than likely can do an eviction for cause for failure to allow entry, but I would talk to your legal counsel first as to what your exposure is regarding that, because none of us want to get sued, you guys. I mean, that's why I'm here. I don't want anybody to get sued. Me either. So you can serve a 24-hour notice to enter. If they don't let you in, you can serve a 3-day curable breach of covenant. Talk to your legal counsel on how many times you need to do that before you do the final 3-day quit. I know that LA County requires 4 attempts before you can do the 3-day to quit. Other counties are 1 and done. So it just depends on where you are, and your attorney can answer that question better than I can. Because they're in these courts every day. They're in there fighting every day. They know which courts allow what and what doesn't fly. So that's when you want to listen to them, okay? They know. But yeah, if you've never asked for money and your tenant hasn't been delinquent throughout the period, you're at less of risk at retaliation if you're evicting for cause, and cause would be failure to allow entry. That's actually a violation not only of your written rental agreement, but it's also California Civil Code 1954. So it's actually a civil code regarding allowing entry. So definitely something you could consider as if they don't let you in. Because come on, when you're selling a house, there's a lot of things that are going on. You're showing it to prospective purchasers. Your real estate agent needs to get in there to take pictures. They need to, I mean, there's a lot of moving parts of getting in and out of that property, especially if you have an open escrow and now you're doing all of your inspections. And I mean, there's a lot of moving parts there. Remember this. If you need your tenant to do something, approach is everything, okay? So if I wanted to sell my house right now, I would first notify my tenant, hey, I'm kind of in a bind. I get whether you're behind or you're not behind, but I'm in a position financially right now that I have to sell this house or I'm gonna lose it. Or I need to sell this house, whatever. I need your help. I'll give you a rent credit every month if you help me show it. I mean, I try to work with them, okay? I need them to help me so I can make it all come together, if you will. So I just go, what I call knocking and talking, is I go talk to them in person. Hey, I have to sell the house. No offense to you. Do you want to buy it? I asked them first. But I'm going to need help showing it and making it available. And eventually, unfortunately, unless they purchase this as an investment, you're going to have to go. So I try to talk to my tenant, and I'll give you guys an example. My tenant contacted me in April of last year. and said, "Hi, I just want to let you know that both me and my husband have COVID. And we don't know when we're going to pay you the rent." I said, "It's okay. The biggest, most important thing is that we have you back home and healthy. So I tell you what I'm going to do. I'm not going to charge you any late fees at all until you get caught back up and we get back on our feet." Took her 4 months. She always paid the rent, but it was by the end of the month, not at the beginning of the month. I didn't charge her any late fees because I couldn't, but I didn't tell her that. I just kind of held that one close to my chest, keep that card close by. But I immediately said, "Okay, I'm not going to charge you any late fees." "Oh, thank you. That's so nice of you." And I'm thinking, I can't charge you late fees, but don't disclose everything, right? Took her 4 months. Now she's back on track, paying her rent as scheduled, as agreed. And I feel that has to do with the approach when she approached me and how I reacted. Those of us that get frustrated and go banging on the door, we're less likely to end up in eviction court because that landlord-tenant balance has been severed. So if you have a good communicating tenant, communicate with them. They're most likely a good human, okay? Good humans, bad humans. If you have a bad one, I feel for you because this has been a bumpy, rocky, windy cliff drive for us during this pandemic. It's been a little scary. Lots of moving parts, most definitely. Let me see if I have any more questions. If not, I'm going to end this for today, you guys, and I'll be back next Wednesday. Yee. Anybody have anything else? Or I'm going to go. So you guys can go have lunch and go on about your day. And if you need me, I am available. Text, email, call, whatever you guys need. Okay. I'm here. I'm not going anywhere. All right. Nobody seems to have anything else. So I'll end this for today. I will see you guys next week. And play safe, set your alarms. We want to be up at 5 o'clock in the morning on the 15th. Sorry, but hey, if you're going to get 80% of all your past due rents since the pandemic happened, it's worth it. Okay. The alternative sucks. 75% becomes consumer debt that's unassignable. Yeah, that's bad. That's not good for us. So again, if you're going to apply for that money, please watch the fine print. I don't know how long they're going to say that we can't evict the tenant for if we take their money, but I guarantee you it's going to be in there. Could be 6 months, could be 12 months, could be 24 months. I don't know. I won't know until March 15th, but I'm warning you guys, apply for the money. If you don't like the terms, opt out of the program. I mean, that's how easy that worked, right? But at least you got your foot in the door, but know what you're up against. And I'll tell you right now, if it said that you couldn't evict your tenant for 6 months, I'd take the money and sign for the 6 months because chances are we're not going to be able to terminate tenancy for 6 months afterwards anyway. So definitely something to keep into consideration. All right, you guys, you have a great week. If you need me, you know how to find me. And I wish you all the best. Enjoy your lunch. Bye, guys.